I'm going to keep this super high level today because there's a lot of people coming up after me. I just want to talk broadly about the policies regarding unsecured judicial releases. My name is Ben Line, and I'm policy counsel for the ACLU of Georgia, organization committed to fighting for the civil rights and liberties of all Georgians. I'm here to speak in opposition of SB 63 today. We're not in opposition to guardrails. We're not in opposition to public safety. What we are in opposition to is some of the policy considerations, and I'm assuming that they're all unintended because I've had an opportunity to speak with the author a lot when I was back working in Senate research, and I know that these are not the consequences that he wants from the bill, but I want to say that in our experience, in my experience in practice, this bill will lead to unfair targeting of Georgia's poor, an erosion of due process, which undermines the criminal legal system, and as well as making Georgia less safe through increasing recidivism. This bill unfairly targets Georgia's poor, who are much more likely to become justice involved to begin with. 2 points on that I want to consider is the first, that at the point of bond is being considered, that's a person that a judge has already made a determination they are not a threat to society and they are not a significant threat to not return to court. Second point is that when we're talking about setting bond amounts, the judge has to consider each person individually and make a consideration for their ability to pay. 85% at least of criminal defendants in Georgia are legally indigent. That means that for those people who are so poor that a dollar may be impossible, the only reasonable under the Eighth Amendment bond for them is an unsecured judicial release. I had several occasions in my practice of sheriffs calling me to ask the DA for an OR bond back when that was a thing, or judges asking me if my client could put up a chicken that he had and outside of his, he was experiencing homelessness encampment as surety. I just want to go through a few more things if there's a few more times, Mr. Chairman.
You got 30 seconds.
Okay.
Ben. Talk quick.
The last things that I want to talk about, that a person who is kept in jail only because of their ability to pay bond, that has been analyzed heavily by multiple studies and found that those people have worse outcomes and plead more guilty more often just because they're incarcerated and cannot afford to pay for their bail. Our largest policy consideration with regards to this bail is the creation of 2 tiers of justice: the people who can afford to pay bond to get out and those who can't. I know that there's a lot of people after me, so I will leave them to make any questions, but I'm more than happy to answer questions of the committee at this time.
Thank you, Ben. Do you have a question from Senator C? Oh, no, wait. We want to talk to the microphone so everybody at home can hear it. All right.
12.
Go ahead.
Thank you. Because recently in my district, I had a person family member I knew, but the story goes that he had a job but had no money. He was trying to get to the next paycheck, but he couldn't get the bond out because the family couldn't help. What happens on those occasions?
So when we're looking at this consideration for this bill, generally the judge is going to be able to take under consideration. Fortunately, judges at this point in time have a lot of breadth with most charges that if a person is too indigent to pay any amount of bond, they can do an unsecured judicial release. One of my biggest concerns is about increasing recidivism, which is one thing that I want to talk about, which is the other side of that, is that a person who's held for 2 or 3 days that could have bonded out the day before is more than 40% more likely to have committed additional offenses. And so when we're looking at eliminating the ability to get people out timely on offenses that they shouldn't be in, but for their ability to pay, it actually can have an effect in increasing recidivism. And that's what we're trying to address as well.
All right, we got a question from Senator Robertson.
Thank you.
Hey, Ben, it's great seeing you and
Good to see you as well, Senator.
with you. Yeah. Where are you pulling your numbers from?
Sure. So the majority of the numbers that I'm pulling my numbers from can be found in the 2017-2018 report of the Council on Criminal Justice Reform, looking at their evaluation of states specifically.
Ben,
yes.
Yeah, real quick. Okay, thanks. Yeah. Who funded that report?
I believe that was funded by the Georgia taxpayers.
Yeah, and I think I know who the authors are. I think there's some of the numbers in there that tend to be a little squirrely. And you used a phrase, justice involved. What is justice involved?
Justice involved. When we're talking a blanket term for those who have been involved in the criminal legal system. So those, because just people with a criminal history, because not every case results in a criminal conviction, but those are people who can be impacted by the criminal legal system.
So justice involved is somebody that has entered the criminal justice system?
That's right.
Okay, thank you.
All right, thank you, Ben.